Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
One, who started this whole Sedina issue? Was it not the MPP?
Right.
The appeals court mostly deals with evidence adduced by both the prosecution and then the accused. This time around, he has the benefit of at least 3 justices going through the evidence as presented in court.
Right.
Unfortunately, they may not have the body language and the chemistry of the accused and then maybe that of the witnesses. But at least they will look through all the witnesses' statement and everything. And these 3 justices studied all the evidence presented by the former AG and his team, Godfrey Dame. And all their conclusion was that most of the evidence adduced by Godfrey Dame then were poorly done. So let's not try and create the impression. I heard some of their lawyers say, oh, the conclusion was based on a defective charge. No, it wasn't a defective charge. They were not able to substantiate their charges. Moro, let me give you 2 classical examples. Mm-hmm. The charge of willfully causing financial loss to the state. Is it an act or is a process? Because if you say I willfully cause financial loss to the state, it means I entered the state into a transaction, committed the state into that transaction, the transaction was carried out, and after the transaction there was a loss.
Right.
But herein lies the case. Sedina started a process of contracting vehicle for the GPRTU at the cost of I think 84 million. Mm-hmm. The end is MPP takes over. The new Maslock boss comes, looks at the contract and says, no, this is too expensive. Hold on. So the process of commitment was altered.
Yeah.
Then a new price was negotiated by the then finance minister. So the moment you renegotiate, it means that former contract is gone. And then you decided to pay the new price. Sedina did not even commit the country to that payment.
Okay, so it's an interesting point you've raised. And if this matter came up some time back, recently I was here, the Director of Communications, and I raised this issue, whether when you commit a state to a certain contract, is the same as actually executing the payment for the contract. His argument was that if the NDC had won the 2016 election, Maslock would have paid.
So is she being charged on willfully trying to, or potentially trying to, or the law is willfully causing financial loss to the state?
The same question, and he said no.
No, you don't charge on presumption.
So he says once there was a commitment, it means that she would have.
The commitment ended when the contract was renegotiated.
Right.
The moment that the new person came and said, listen, we are renegotiating this, and then the person buying did not say, I am going to court for, judgment debt, and accepted to also renegotiate, it means the person has re-entered a new contract.
Right.
So the old contract is gone. So if you go and present this to the appeal court justices, you expect them to accept what you did in a rush and also convince somebody on this. Then there was another weird one. Conspiracy to steal and stealing with Obatampa. That there was records of Maslock transferring 500,000 to Obatampa Microfinance. Then Obatampa Microfinance now comes as a witness to say, yes, I took the money, but I paid the money back to Sedina. Okay.
At Bachona.
I'm coming there.
Okay.
Where is the evidence of payment? We were able to track the money all the way from Maslock to Obatampa. There was paper trail there, everything. But when the money was leaving a microfinancial institution to go back and pay, there was no paper trail. What is the evidence of payment? He said, oh, I put the money in Ghana Must Go and went and handed it over to her. Is that how a microfinance operates? Is there anything that shows that the woman received the money?
Yes.
He said, oh, there was a text message. Where is the text message? Oh, it's gone. And you expect justices to listen to this and accept. Because according to the the appeals court judge, they asked the person that show the evidence that the woman collected the money. He said there was no evidence. So if there was no evidence, you paid the money in 2014. In 2015, the same institution was still asking you to pay. And so when they asked you to pay, I said, how do you pay something in 2014 and in 2015 you are still being asked to pay interest on the money you took in 2014? And so I reminded her that the money I gave you, your people are still chasing me for it too. And she replied, I'll fix it. Okay, where is the evidence of that WhatsApp message? That one too, the witness couldn't produce it.
So
Moro.
the receipt.
So what did she actually steal?
The receipt, which was a photocopy of the monies which he claimed, or Batampa claimed, he had returned to Sedina. Why did the court say? Why did the Attorney General say that the duplicate was not evidential enough?
The woman, the woman says, I doubt that signature on that particular.
So I'm talking about it's a Sedina's lawyer, not
yes,
the yes. Sedina's
the woman denied that she cannot authenticate that thing as her.
But she said the signature looks like hers, except that she cannot authenticate whether indeed.
Moro,
she said.
What I'm saying is that if an institution gives you money, do you give the money back to a person or you give it to the institution?
You give it to the institution. I agree with you.
So how can a microfinance or organization say an institution gave me money? A person comes demanding, and I decided to pay the money to the person rather than the institution.
Now, does the fact that they didn't go through the right process? Yes, I agree, because it ought to be administratively official, which is because Maslock paid into an account.
Yes.
So if you're returning it, you return to a Maslock.
Maslock.
I agree. Okay. Now, if indeed, and I mean, because you and I were not there.
Yeah.
Right? If indeed it was the case that Sedina asked them through that WhatsApp chat, and I'm not saying it's true, I'm just conjecture, asked them to meet her at Bachuna.
Sure.
To bring the money back to her. If they're saying that the interest rate is high, 24% is too high, they don't want. Okay. Are you saying that because they didn't send the money to her back into the account of Maslock, automatically mean that it is not possible that there was some meeting somewhere where the money was given to Sedina?
Moro, we are talking about criminal charges.
I agree with you.
Not civil charges.
I agree with you. Which is
must be proven beyond all reasonable doubt.
Yeah.
So if an institution gives you money, what the justices expect is that you pay back to that institution.
No, sorry, Fuseini. The reason why I'm asking this question because you said you think it is highly implausible for Batampa to have met.
If it's a person to person, I can understand.
Yes.
But I said I'm giving you money. You said you have not given me the money. That's a different thing.
Yes.
But I'm talking about institutions dealing with each other.
Yes.
The money moved from Maslock all the way to Obatampa can be traced. But when the money left Obatampa to Maslock, it cannot be traced. It can only be traced to a person in Maslock.
Yes. I agree with you, there is no evidence.
And aside that, you see, when justices are dealing with issue, they deal with everything holistically. This is the same Attorney General who in the ambulance case was coaching Japa, an accused, to go and twist witnesses against another accused person so that he can get the chance to imprison that person. So what makes you think that, Sedina is in trouble? Obatampa, if you're able to give me this kind of witness statement, we can get the chance to nail her. So go this particular route. And the guy too, excuse me to say, did not also think through that this particular route I'm taking is criminally minded. Because who in his right senses will believe that an institution gives you money, pay back the money to that institution, you say, no, I decided to go and give the money without any paper trail to the person in charge of the institution. And we expected this particular thing to hold before the justices.
Yeah.
If Godfrey Dami expected it to hold, well, I'm not sure the justices within their right frame of mind will allow this to go through. So, Moro, almost all the charges preferred against the woman were flawed.
Okay.
It was rushed.
There was something Fiifi Boafo read. Fiifi, I don't know whether you can. I wish you could give it to Bright for Bright to put it on the screen. There was something read about what Dominic Ayene said.
Yeah.
You know, and in fact, that is what formed his basis to say that once the evidence was not sufficient enough, as we're being told.
That is why I'm saying that particular aspect was even amended.
Yes. So
the appeals court allowed the Attorney General to amend it.
When was that?
Yes, he did the yes, it was ratified. In 2026, it was ratified.
Dominic Ayene
This was his final submission, and he said it was rectified. At what point?
There was at no point. The inconclusive documents that they were talking about, the inconclusive evidence and code that he was talking about, all those things were taken care of. In fact, there was an appeal made to amend those particular things. And the appeals court allowed it because the appeal court will normally go through all documents. So it's even in their own interest to get the full picture.
Okay.
That is why they allowed it. And everything was presented. You see, unless we want to be emotional about this particular case, if we are actually dealing with the law that MPP actually proposes for us to always deal with the law, I don't see the qualms about this.
Right.
And if you are saying that the Attorney General was deliberately doing this, this was a judgment from the appeals court justices. 3 of them. 2 of them even appointed by Nanado himself. So, is it that the Attorney General was actually in, how do you call it, in collaboration with the justices decided to do this? Why are we refusing to read the actual judgment?
Right.
But decide to speak emotions rather than law?
Right. Okay.
And so we are just casting innuendos, we are just casting hypotheses. Why couldn't it be done this way? But the thing is in front of all of us, black and white. You see, we may not be lawyers, but one thing I keep saying is that whatever the lawyers quote, after quoting the articles, the rest becomes English. And by God's grace, we all did grammar and comprehension. So we can actually understand.
Right.
So please, Goro, for me, it's just a matter of let's try and put political spin on this and make it a political capital. Otherwise, there is nothing wrong with this judgment. We are just not being fair to the woman.
Okay.
All right.
Okay. So somebody has sent me this, and the person has added the document. When the Attorney General's Department raised an objection relating to the full records of appeal, it filed an application to rectify the records. That is to say, to ensure whatever process or exhibit or document not included in the records are included. The Court of Appeals granted the application and the record was subsequently rectified. That was even before Sedina Tamakloe had been extradited to Ghana. And it says fine proceedings of that day and the ruling of the court below. It is totally false that some exhibits were missing from the record the Court of Appeal considered in arriving at the decision. And the person sends me this.
Okay, but Moro, a quick one on that.
Yes.
So, even before Sedina was extradited, he says,
okay,
wait a minute. Was the court hearing Sedina's appeal case before her extradition?
But the case was ongoing.
Ongoing where?
She was coming for trial. Because she was pronounced guilty in her absence. I'm coming. She was pronounced guilty in her absence.
Yes.
And her lawyers have started an appeal process, which the Attorney General was objecting.
Right.
So when she was
You mean, and at the time was Godfrey Dami?
Yes.
But I thought Godfrey...
They did the appeal process even during Godfrey Dami's time.
It did not.
That is why they started.
It did not happen.
Which one did Godfrey say he wasn't even aware?
It's the same matter. So
Godfrey wasn't aware of that.
Yes,
it was done. The AG,
You saw that Godfrey right?
Yeah,
he didn't know anything about
he
that.
was pretending he didn't know. He said, "Oh, it didn't come to his attention." It's different from I didn't know.
No.
You mean the fact that it didn't come to his attention does not mean it wasn't happening?
Don't mind him.
How was
the
it
AG's department.
How was it happening?
Oh, come on.
The Attorney General sanctions every case before the matter.
My brother,
go
and check.
The
first show that it happened, and he was saying that, he as Godfrey Dami wasn't aware.
Yes, that is not aware.
No. Because it was the AG department that opposed it.
Okay, all right, please go ahead.
Yes. He said some things which I need to correct.
Yes.
And he's not the first person to say that, oh yeah, there are 3 justices of the Court of Appeal. There are 3 justices at the Court of Appeal. Suggesting as though if there are 3 justices at the Court of Appeal, whatever they say is final. No, that's a Court of Appeal.
Okay.
There is a Supreme Court. It therefore means that if there are 3 justices of the Court of Appeal, whatever they say is final. It is not. They could be wrong. So stop making reference to 3 justices. We have said in this country where 7 justices are the most superior court, the Supreme Court, and you call them names. So now, referring to 3 justices at the Court of Appeal as though that is a Bible or that is a Quran, that is not the case. He talked about the fact that, well, there was no evidence of payment from Abatampa. That is not the case. Indeed, at the High Court, the people adduced evidence to the effect that, yes, we took the money. When we were supposed to pay the money, the woman asked us to meet her as Pentex Robachona and give the money to her. When the people were being chased to pay the money, what did they say? They went to her, madam, the money, we've given the money to you. Your people are asking for money. They went to her office and she actually gave her a personal receipt, acknowledging that, yes, I've taken the money from you.
But she's saying
when the matter went to the High Court.
But she's denied that.
No. She's not denying. She said she's not sure. No, don't you know your signature?
No, but that receipt you're talking about is a duplicate. we don't know what the
It wasn't even the original.
So the fact that it's a duplicate doesn't make take away something from the fact that it's a
well, the court won't accept a duplicate without original.
The court accepted it. The High Court accepted it.
That is why the court dealt with it.
No, wait a minute. She did not object to it. She did not.
She said she can't authenticate the signature.
Wait a minute.
So
if it is not your signature, you say that is not my signature.
So,
you don't say
Fiifi, sorry about this. But if you bring a document to court and it's not the original, you bring a duplicate. Doesn't the responsibility lie on the prosecution to produce the original?
Wait a minute. The person, it is not the prosecution that issued the receipt or received the receipt.
Right.
The receipt was given to Obatampa. Obatampa was asked, do you have receipt of payment? And said, well, I have this duplicate of the receipt she gave us. The woman was asked, and then she was talking about whether she's not sure if that was her receipt or not. More, what it means is that the woman received the money. Yes, you can say that she did not. Oh, please. But do not say, no, wait a minute. Do not say that the woman, there was no evidence or there's nothing to show that the woman indeed called the people for receipt of that money.
What was the evidence?
Wait a minute.
They couldn't produce it.
You also sat here and said that there was a coaching. Where? Are these evidence to show that indeed Obatampa was coached to go to court and say that there was no such evidence?
No, I'm just saying.
So
the character of Godfrey Dami in the Japan case.
If we are talking about character,
the same thing he was doing.
Allow, I heard you. If we are talking about character, at least we know one person who has demonstrated it beyond reasonable doubt, and it's the Attorney General of the Republic of Ghana.
Any witness.
This is the Attorney General who has acted.
Person to go and lie on oath. He has not done that.
We are not doing a shouting match.
No, you started it when I was talking. You were coming in.
No. Allow me.
No. So don't make it
This
look as
is the Attorney General who every NDC person accused, he has ensured that person is freed.
He has not coached any witness.
He has ensured that person is freed.
He has not done that.
Can you trust that Attorney General? What would he do differently in the case of Sedina?
He's not even under.
She has done it
by the legal counsel.
Demonstrably for everybody to see that for him, he does not believe that any NDC person must go to jail. So why would you expect anything different from her?
Okay. All right, let's move on. Well, the good thing is that the Attorney General says he's appealing against it. And
Moro,
he's also
for me, one thing is clear to me. This Attorney General in Dr. Dominic Ayene is not under investigation by the General Legal Counsel. There's not been any prima facie case formed against him for coaching prosecution, an accused person to go and lie under oath. No, he's not done that.
You said
so for me,
you're saying this repeatedly.
That must be put on record.
Okay.
Because if I hurried somebody through a criminal trial, just to be able to get my way to jail and say I have jailed an NDC person, and the appeal court points out the defectiveness of my charges that the charges that are preferred against the person, and it comes out that I did a poor job. I was just trying to maneuver to jail somebody rather than taking the person through proper justice. That is no law.
All right.
I'm not PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.